respected Rohanji, my fellow panelists, distinguished delegates to this important conference seeking faster justice. I am an academic, having been teaching law for nearly half a century. I have been involved in some activities relating to legal and judicial reforms for the last nearly 2 decades and more. In the Law Commission, outside the Law Commission, in the Department of Justice, in the Judicial Academy, interacting with judges and naturally interacting with lawyers all over the country. This concern for quicker, inexpensive justice, which is a fundamental right of every Indian citizen, has been engaging the attention of all sections of people for a long time. But Madhavaji has made a movement out of it, mobilizing people to assert their rights, compelling the parliament, compelling the government to do something about it, because we have waited for too long. Nearly 6 decades have passed since the constitution was adopted, and the excuse of lack of resources no more can be said by any government. We are fairly comfortable in resources. How come that one has to wait for 20 years in a civil case, or perhaps 5 to 10 years in a criminal case, to get a decision from our judiciary? This is affecting the development of the country. This is making the poor suffer a great deal. As to why is it that a democratic government, a popular government, is not able to settle their disputes and enable them to enjoy their rights in reasonable time? Now, this is not therefore a new subject. We know the problem and the reasons which contribute to the problem, because it is studied, to my knowledge, at least by about 25 expert committees of judges, lawyers, government officials. So we know the problem, and each of these committees and commissions have recommended a number of changes in the structure of the judicial system, in infrastructural resources, increasing the number of courts, procedural changes to civil and criminal procedures. All recommendations are there in these reports. In short, we know the problem, we know the solution. Then what is the hitch in developing a faster system of justice, without which the poor people suffer the most, not the rich people? They can afford to stand a litigation for 20 years. But the poor people, if they have a cause, they would not dare to go to the court, because they know it will be 20 years and a lot of cost to the court as well as the lawyer. Therefore, they suffer injustice, which is still bad. Therefore, ladies and gentlemen, I am happy that I am associated with this movement. In fact, I came mainly to express my solidarity with the movement and its leader, whom I know for the last few years, have been working at various levels to make the voice heard and something be done, and done quickly. Therefore, I came to express my solidarity and give you some very quick suggestions which probably you already know. Doesn't contribute much. But I was talking to the gentleman who accompanied me from the hotel as to what we can do. We can perhaps analyze the recommendations which require priority consideration on the part of the judiciary, on the part of the members of the bar, on the part of the government, central government and state government, even on the part of the litigants. So perhaps the respective roles and responsibilities for faster justice will have to be analyzed and allocated, instead of merely passing resolutions and putting the blame on the government or the judiciary to each one of us in a democratic country have our own roles to play for better governance. And from that perspective, I am submitting to you that the constitutional framework is better, everybody knows. The Constitution has set up an independent judiciary, truly independent in many respects. I know the judiciary of several countries, and I am proud that we have a judiciary which is independent and capable of giving qualitative justice comparable to the justice available in any developed country in the world. So we are proud of our judiciary, no doubt about it, in terms of quality, in terms of integrity. The Constitution has guaranteed that independence. You know, I don't have time to go into the provisions. So therefore, the machinery that has been set up by the Constitution, with the Constitution promise would give justice, social, economic and political, which Ambedkar wrote into the Constitution, to every citizen on an equal opportunity basis. That is one first step that the Constitution has done to make access to justice available to every citizen. The second thing they have done is an integrated bar. You know that under the Justice S.R. Das committee, at the time when we became independent, there was a Orissa bar, there was a Madras bar, there was a Travancore bar. It's all disparate. Some people were qualified to practice, some were not qualified to practice. So in order to provide justice to the people, the first important requirement was how to integrate the bar, determine the standards of entry into the bar, and equip the bar to cooperate with the judiciary to deliver justice. So on the basis of that S.R. Das report, the Parliament has passed the Advocates Act, given the monopoly to practice to the lawyers, ask them that you determine who should be practicing under what conditions, what discipline, and today we are told that we are the largest bar in the world. Why are people not getting justice? When you have, of course we know that we have only 18,000 judges, but we have a little over 13 lakh lawyers. What are they doing? They are fomenting litigation. Or are they enabling people to access justice administratively or otherwise? And I will come to you. So I raise the question because many of you are lawyers. What are you doing for faster justice? Do you necessarily have to litigate in court to provide justice? When the Civil Procedure Code provides in Section 89 of the CPC that you must go and try to settle the dispute through mediation, conciliation, arbitration, lok adalat, negotiated settlements, several other alternatives. But how many lawyers think of those initial attempts? Or lawyers simply try to file yet another suit. From one cause of action they make 4 different causes of action, some in a civil court, some in a criminal court even. A woman is coming for a divorce or a separation or a maintenance. Now how much time, this is supposed to be conciliated and settled. That's what the Family Courts Act says. But instead the lawyer will make all sorts of claims of harassment, domestic violence, this and that, a criminal case, a civil case, and make the life of the woman totally destroyed, miserable. So therefore, ladies and gentlemen, the Parliament has integrated the legal profession, given them the monopoly to assist in dispensation of justice. In fact, I would argue that 50% of justice dispensed in this country is through lawyers for both sides. If they are able to find out a settlement of what is fair in that dispute and submit to the judge, there ends a case. But you fight, keep on fighting, endlessly asking adjournments. Who is there defeating quicker justice? It's the lawyers who are defeating quicker justice. So please analyze from that. Thirdly, Constitution provided a cheap and expeditious remedy for accessing fundamental rights. Today you can access the Supreme Court of India by sending a letter or a telegram. On behalf, if the aggrieved person himself or herself cannot reach the Supreme Court, on behalf of her or people situated similarly, one can file a public interest litigation. And when it is a constitutional litigation, it is decided in few weeks. It has to. That is why the constitutional courts have been given what is known as the writ jurisdiction. They can gather the evidence immediately through commission or through issuing notice to Advocate General or the Attorney General, as the case may be, and immediately give remedy, even interim remedies. If you are unlawfully detained, within days you will get released. So therefore, ladies and gentlemen, we need to appreciate how the Constitution has tried to guarantee quicker justice and is being made available. Constitution also directed the state to ensure that appropriate schemes are evolved under Section 39, Article 39A for legal aid. And that's a very sorry state of affairs. Why legal aid is not able to provide justice to the poor. The Constitution recognized the special customs of the tribal people, for example, and preserved the tribal councils as capable of dispensing justice. They don't have to go to court for litigating. They can preserve their culture and identity by the tribal council, by customary practices constitutionally guaranteed under the schedule to the Constitution. So if judicial system is thus well organized under the Constitution, we need to find out the cause for delay on the human beings who are involved in its administration. There is no institutional infirmity. The Constitution has provided and further elaborated through a number of legislations. Why is it in a place like Orissa, we don't have Gram Nyaya? A legislation was passed by Parliament in 2009 and brought into force, and every state was asked that in every village and cluster of villages, you can set up a Gram Nyaya with civil and criminal jurisdiction, which will dispose of cases on the spot within that same day. But neither the lawyers want that, nor the judges want that. Much of the litigation which now go to the court could have been settled in the village itself through the Gram Nyaya, which is the lowest level of the Indian judicial system. The central government has promised 5 years full expenditure on Gram Nyaya to the state. But why the states are not? We must direct on that state, implement the Gram Nyaya Act, appoint the judges, and let the judges go to the village. It's a mobile court, it's a hybrid court, both civil and criminal jurisdiction. Institutional machineries have been provided, but we the lawyers or the legal community have failed the people of India. Ladies and gentlemen, I would like to submit to you, because that we did not give this access, what is happening? People go to panchayats, people go to mafia groups, with the result that you find that there is lot of denial of justice by these. Now, if you are to ask a judge or to any other people who have examined the question of delay, you examine the cause of delay, I will give you 5, 6 quick and you can make your judgment. One is workload. When India became independent, we were about 160 million people. And we had about 12,000 courts. Therefore, there was not much reason for delay. And civil cases were more at that time. Criminal cases were few at the time of independence. Now today, from 160 million people, we are today 125 crores of people. And the number of courts that we have, from about 12,000 at the time of independence, it is 18,000 courts today. And out of which only 16,000 are functioning, because there are more than 2,000 vacancies not filled up. So therefore the workload of the court has increased 10 times without the number of courts not getting increased. I must tell you for your information, according to official records, an average judge in India tries and disposes of about 1,200 cases every year. This is world record. And how do they do it? The type of infrastructure that you give to the trial courts you can see in different parts of Orissa. There may not be a fan when the temperature is 40 degrees. There may not be chair, there may not be papers, there may not be any other for the civil judge junior division, or I am not talking of High Court and Supreme Court judges. Then 90% of the Indian litigants get their justice in the trial courts, not in the Supreme Court. So therefore, the workload of the courts have considerably increased. Judges have been working very hard and have been disposing of about 1200 to 1500 judgments a year, which is, after all, they have to give reasons, they have to take evidence, they have to follow the entire procedure. That means they are working very hard, which need to be, and it is because of the lack of commensurate increase of courts that we have a delay. Second is bad governance. What is bad governance? I am telling you that 60% of India's litigation is that of government. Government is the litigant, either on the criminal case or the civil case. And the government litigation can be contained if only they do their duty. I will not go to file a case against the government if my provident fund is timely relieved. Now the point is that the government has, the functionaries of the government have not been doing their duty. Their duty is not enforced. I have to go to court to compel them to do their duty. Or they exercise their power wrongly because of corruption and other reasons. I need to go against the government. So the government is the greatest litigant. And if the government, and the time of the court is occupied by the government, so the ordinary person has no time getting from the court. So government litigation needs to be contained. There must be some machinery within the government to settle there, rather than continue litigation at the first level, second level, appeal, etc. The third reason is inadequate funding. You know, the judiciary was one department of the government which did not receive any planning commission funds. It's not a planned item. How can it not be planned item? Even jails are planned item. But courts are not planned item. It took 60 years for the 13th Finance Commission to say no, judiciary is a part of the development program. And setting up the courts should also be receiving the planned funds. That's how in the last 10 years or so, judiciary started receiving money from the government under the planned grant. So therefore, there was something distorting in this regard. Absence of adequate reform in judicial proceedings. Now here I come to the judiciary. If you ask a judge here, how many cases are there in your court? He might give you a figure, but not necessarily the right figure. If you ask him what are those cases, are they relating to matrimonial or land or this, that, he has no idea. He will ask you ask the registrar. You are presiding over an organization as the judge over 10,000 to 15,000 cases, the nature of which you are yourself not sure about. Unless and until you plan your court and manage the court according to management principles. Now the management revolution which has happened in the private sector has not touched the judiciary. Look at their way of record keeping. Look at their way of issuing summons. This all could be done through the mobile or by the email or this, that and the other. Neither technology nor management has touched our judicial system. Who are to be blamed? Naturally the lawyers and judges. Who else? Is it because of lack of money? No. At least for the last 15 years I know there is plenty of money for digitalization, for computerization. So therefore neither there is case management nor court management. You are, if you were to ask for judicial statistics, because statistics is the basis for planning, we do not have say. You might have told that there are 3 crore cases. I tell you, if you try to analyze what are these 3 crore cases, it may be perhaps 1.5 crores only. How many cases are more than 5 years? Some figure you will get. That figure is produced by some uneducated clerk in a court who will make a guess and send it, that's all. So our judicial statistics is in such a confusing state. Today they are getting a national judicial script, making statistics promptly and assemble that. An adversarial system, you know, the system which we inherited from the British is that every case will have to be litigated, and you will find all that the plaintiff has asked for will be denied in the written statement by the opposite party, and then come on proof. There is things which need not be proved by evidence can be taken judicial notice of, is also being asked to be proved. Unnecessary witnesses are summoned. Cases are adjourned. In other words, there is no pre-trial planning, which could have been there in the civil procedure code or even by rules of court, but it's not a practice in our courts. With the result, adjournment is a few years ago, the first 3 hours of a court's time was calling cases and adjourning. 10 o'clock till 1 o'clock, if this is the practice, what is the work that you are doing? Totally mismanaged. But people should talk about it. The multiple appeals, I don't think that any other country gives the luxury of 4 or 5 appeals or reviews, revisions on every matter. And if you have the money, go up to the Supreme Court. And if you are somewhere in Haryana or UP, which is nearer to the Supreme Court, your cost is less. You keep on filing on rent control or this, that, all in Supreme Court. Somebody should manage this. This is the system of judicial administration. Easy adjournments. In spite of the fact that the civil procedure code says 3 adjournments and no more. Which judge? Why is the judge not able to impose the cost? Now recently they have started doing, Supreme Court has started doing, asking 10 lakhs to be deposited for the cost of the other party and the judicial time for having wasted the time. They show the cost and then you are asking for adjournment. If judges start imposing costs for seeking adjournments more than 5 in a case, you will find how quickly justice will move. I'll suggest to you that there is no witness protection. No witness protection for whistleblowers and others, which make people keep away from court, even when ordinary citizens want to assist the court. Poor judicial training. Some lawyers tell me that the delay is because the judge doesn't understand. And therefore we have to repeat the arguments again and again to make him understand. So if you put an incompetent judge there, what do you do? So therefore you are saying that judges must be trained for the job. And they must be continuously trained. And they must not be transferred from one jurisdiction to the other. When you get trained in family court litigation, if you put him into accident tribunal, then he is to be trained all over again. So judges should be kept at least for 10-15 years, which is not the policy of our judiciary. So poor judicial training and performance assessment, how are you assessing the performance of a judge? Some quota is there, and that quota is manipulated. It doesn't tell who is working, who is not working. So everything which needs to be done within the judicial system by the lawyers and judges are not being done. So much so today, courts and lawyers seem to exist for themselves and not for the people. Well, non-reform, now I come to the bar which I wrote, about which I told you. Poor quality, when lawyers are poor, they don't read. They don't prepare they copy the plaint. What do? The petition is being copied, not applying the mind. And therefore, if lawyers, when we talk about that, the lawyers turn around and say it is because of you. You have educated them and gave the degree. I'm a law teacher. So therefore, legal education is bad. And when they said that the legal education is bad, we in return tell the Bar Council that you have maintained this, you are supposed to maintain the standards and you are corrupt, you are not doing your duty, therefore law colleges are not doing that. So there is a conspiracy of lawyers, law colleges, judiciary to keep the public ladies and gentlemen, ethics, less said the better on question of ethics. And we are living today in an age of specialization. Can there be a lawyer who can be doing every aspect of litigation? Whether it is a matrimonial matter, labor matter, tax matter, criminal matter, constitutional, I don't think so. It's humanly impossible. But lawyers are yet to take to specialization. So that is another, and how many lawyers in Orissa bar are using the computers, I do not know. Are you still taking the digest and the reviews and all that? God save you. Don't talk about delays. All right. And finally, the poor use of technology, and these things have to be changed. I believe if the Society for Fast Justice were to identify all those reforms which have been recommended by, what I am saying is all there in the report. Right from Sadarwal report, the 14th report of the Law Commission of India, 1958, in 2 volumes, Civil Procedure Code and Criminal Procedure, have identified all these illness of the judicial system. If we identify in categories, and this is what the bar is supposed to be doing, this is what the judiciary is supposed to be doing, this is what the central government is supposed to be doing, it is much easier to find the cause of speedier justice, rather than talking vaguely in things like that and creating a sort of animosity among the ignorant public against the judicial system will be a dangerous trend. So we need to study, and I am sure that meetings like this where you discuss it, analyze it, and do not hesitate to be reflective on your own role, that will perhaps be contributing to an informed debate on the subject, and thereby helping the Republic to achieve its promise of justice, social, economic and political. I appreciate having given me a chance in the midst of a presentation. I apologize to you, sir, for having come. I need to go to Cuttack for another lecture at 4:30, so I would request you to allow me to leave.